Most people in the UK have no idea exactly what a debt collector is or isn't allowed to do when chasing debt. Many wrongly assume they have far greater power than they actually do. Thankfully, there are regulations put in place by the Financial Conduct Authority that limit what they can and can't do. These regulations exist in order to protect you from any kind of unfair practices. So what are debt collectors and creditors allowed to do? They can chase you regarding your debts. If your debt is legitimate, then the debt collection agency that's been hired by your creditor has every right to keep contacting you in regards to it. They can contact you via phone, via post, or face-to-face house visits. While you cannot stop them from contacting you entirely, you can control how they contact you. If you don't want them visiting your home or contacting you via phone, you can write a letter to them informing them that you'd only prefer to be contacted via mail. As per guidelines authorised and regulated by the Financial Conduct Authority in the UK, they will have to oblige. If they keep contacting you via phone after you've specifically asked them not to do so, then you can report them to the FCA. They can show up at your home. As mentioned, debt collectors do have the right to show up where you live in order to talk to you about your debt. While they can show up at your residence, keep in mind that a debt collection agent does not have any extra legal powers. They do not have the right to force entry in your home, either by forcing your door or by pushing you aside when you open the door. In fact, you don't even have to answer the door to them if you don't want to. If a debt collector shows up at your house after you have informed them that you prefer to be contacted via mail, then you have every right to report them to the FCA. They can add interest and/or additional charges on your debt. Technically, this is something that your creditor or creditors decide to do. The debt collection agencies registered in England act on their behalf in order to increase the interest as stated by your creditors. This is completely legal and within the confines of the law, and is one reason why it's always best to attempt to settle any debts as soon as possible to prevent your debt from continuing to grow. You can send your creditor a letter requesting them to freeze charges while you get your financial situation in order so that you can start paying them back. If you're transparent and sincere with the explanation of your situation, then there's a chance that your creditor will understand and agree to freeze interest. They can take money from your accounts. In some situations and for some types of debt, a debt collector can take money from your account. Taking money from your connected accounts may seem like an infringement, but it's completely legal according to the law in the UK. If, say, you have a credit card debt and have a current account with the same bank, then they do have the right to dip into your account and take payments towards your debt. They do not require your permission to do this, though they do have to warn you in advance. Your creditors can apply for a court order or a county court judgment. You may receive a letter informing you of a court order from your creditor in relation to your debt. It's really important that you fill in any court forms you receive and make a reasonable offer of repayment. The court will then decide how much money you have to pay back in the form of repayment. You must stick to whatever the court decides. If you don't, your creditor has the right to take further action against you. Your creditors can issue a default notice. A default notice is usually what you receive if you haven't made a payment towards your credit card debt or towards a personal loan. If you have received a default notice, this means that your creditor or the collection agency have begun the process of defaulting or cancelling your account. You get about 2 weeks after you receive the default notice to get your payments in order and amend your situation. If your account does get defaulted, it will negatively impact your credit rating and stay on your file for 6 years. If you lack the money to pay off your debts properly, then it's a good idea to contact your creditor and explain your situation to them. Try to be as transparent as possible. They may give you some extra leeway to get your financial affairs in order. Your creditors can issue a statutory demand if you have debts in excess of £5,000. Then you may receive a letter from your creditor informing you of a statutory demand. This is a document issued when a creditor is planning to make you bankrupt. When you receive a statutory demand, it's important that you never ignore it. You have to prove that you can afford to pay the debt owed to your creditors. If you're unable to show this, your creditors will use the statutory demand as well as your response to begin the process of making you bankrupt. So with what they can do covered, let's look at what they're not allowed to do. They are not allowed to harass you. Whilst it's important for you to be communicative with your creditors regarding your debt and how you plan to pay it back, that does not mean a debt collector is allowed to call you every hour of the day. A debt collector is only allowed to call you within reasonable hours on weekdays and not at all at weekends. They also have to oblige if you request that you'd rather be in contact via mail than phone. Debt collectors can't contact you or visit your home at unreasonable times of day. For calls, most people would agree that calls before 8 AM are too early and after 9 PM are too late, but your circumstances might be different. For example, if you work on a night shift. If you can't take calls at certain times, then tell them. They should keep a record of this and avoid calling you at these times. You're well within your rights to complain if they keep calling or keep visiting your house at times that you told told them to avoid. They are not allowed to visit you at your place of work without you giving them specific permission to do so. Before this rule was put in place, some debt collectors would show up when you're working and try to make things awkward for you as a way of pressurizing you into paying. Not only is this malicious, it's also illegal. You can report the debt collection agent or the debt collector to the FCA or even sue them in a court. They cannot breach data protection laws. This essentially means that a debt collector is not allowed to share your financial information or any details regarding your debt with your family, friends, employer, colleagues, or anyone. They are only allowed to deal directly with you. This keeps your situation private and prevents them from trying to embarrass you into paying. They cannot threaten you with legal powers that they don't have. A debt collector could attempt to threaten you by pretending to have extra legal powers that they don't really have. For example, a lot of debt collection agencies make their letters look like court documents, and many debt collectors threaten to send bailiffs. This is something that they do not have the power to do. They're not allowed to increase interest because you missed payments. Your creditor can send you a letter to ask you about why you missed a payment. They can even issue a statutory demand if you miss too many of them. However, they are not allowed to increase interest because you missed scheduled payments. They cannot lie to you. A debt collector may not be the most pleasant person for you to talk to, but under no circumstances are they allowed to lie to you about your debt, your situation, or their powers. So what should I do if a debt collector violates FCA guidelines? If you feel that a debt collector has breached FCA guidelines, you should collect what evidence you can, such as noting the times of calls, what was said, saving up letters, getting statements from your neighbours, and so on. Once you've gathered all your evidence, then send a copy in the form of a letter to whoever has been harassing you, informing them that harassment is a criminal offence and a breach of FCA guidelines. They then have 3 days to respond to you informally. This could be via call or email. You should always complain to your creditors first, but if that doesn't work, you can complain to an authoritative body such as the Financial Ombudsman Service, the Citizens Advice Customer Service, or the Financial Conduct Authority. Of course, the best way to deal with any debt collector is by sorting out your finances before things escalate. If you're struggling with debt, then there are options available here in the UK. Some are free to use and others include fees, and each will have their own pros and cons. If you want to learn more about the solutions available, then we've created a really great form that you might be interested in checking out. Click the link in the description to get started and answer a few multiple choice questions like the total amount of your debt, how many people you owe, your living situation, and we'll connect you with one of our trusted partners so you can find out more and start taking steps towards improving your financial situation.